Hello everyone. I hope we are live and yes, people are here. Okay, so today's topic. So let me start with today's session. Yeah, hello everyone. Okay, so I have Amal. Hello. Yeah, good evening everyone. Welcome back to our one more live event of this week, that is prison laws in India. So in today's session, in today's live event, which will be lasting for about an hour, so I'll be speaking about the prison laws which are prevalent in India, and I'll be giving you a brief introduction, though not the deep insights, but I'll be taking you through the overall laws that are applicable for prisoners in India. To start with, what is a prison? So prison is a penal institution, that is an institution which is provided reside where the residence is considered as a punishment. Okay, so this is also called as jail, and it is also known as prison. So it is a term which is used interchangeably. Thus, looking into the Indian prison system, it owes its origin to Dharma, that is, we can find it in Smritis and we can find it in Shruthis also. And then later on, in many of the work like Manusmriti and others, we can find reference to this prison system. And then later on we had this Mughal period, even then this prison situation was there, and then even in the British period the same system was followed with many changes, with many enactments. But after independence, our Indian lawmakers brought many legislatures and brought many reforms in the jail system. This jail system was originally from the London. So it is considered as the birthplace of modern imprisonment. So this, we all of us know Jeremy Bentham. So he was a famous jurist. So he was totally against this system of death penalty. And henceforth he created this concept of prison, and he stated that the prisoners will be, that is the convicts will be put up in the jail. But even before this, Jeremy Bentham suggested this prison system, in our India we can find the origin and we can find references in our Dharmas, in our Smriti and Shrutis, as I said. So speaking of India, Tihar prison, that is Tihar jail, it is also called as Tihar Ashram, is the largest prison complex in India. And the first central prison was in Madras. So this is all about the prisons, and as you can see in the slide, so why do we have this prison system? Why do we want it? Earlier, before the introduction of this prison, there was only punishment, either punishment of death, or there was this punishment for eye for eye, tooth for tooth, wherein the person was not given a chance for correction or not given a chance for improving himself and coming out as a better person. So to provide an opportunity for the convict to correct himself, to understand his mistakes, and to give him another chance, this prison system was brought into force. Moreover, it is a kind of correctional mechanism wherein people are asked and provided another chance to correct themselves and come out as a better human being. Next, types of jails and prisons. We have these many types of jails and prisons in India. So the first one is central jail. So central jail is considered as the biggest jail, like it is more bigger when compared to that of the other jails, and also it has more facilities. So don't go by the name central, that it is taken care by the central government. No, it is called as central jail because it is vast in the size, and also it has more security thing, and also it has more features. It may be the medical feature or any other feature for that matter. And if any convict if there is chance of his escaping, or if he has been told with a grave imprisonment or a longer term imprisonment, say about like for more than 2 years, or he is medically sick and needs attention, or else he is a VVIP kind of person, then under those circumstances the convict will be put for the central jail. And next we have district jail. District jails are the ones which are in the district level, wherein they will not be as huge as when compared to that of the central jail, but they will be also having adequate facilities. And next we have sub jails. Sub jails are the one which are at the lower level. Now, if the district is huge, or if the place is like more, or if the crime rate is more, under those circumstances, the state government can establish the sub jails. Next, we have women jails. Women jails are, as the name itself suggests, they are specifically made for women convicts and women under trials. Next, we have brothel schools. Brothel schools are nothing but reformative schools wherein juvenile offenders are kept. So that is called as brothel schools. Next, we have open jails. Open jails are the one which does not have more security. Now, if the jail inmate, that is the convict or under trial person, has lesser chance of escaping, or if he is in the reformative stage or any other, if they feel like, then they can be put up in the open jails, wherein they will not be having no much what I can say, no much restrictions and other things. That is called as open jails. And next we have special jails. Special jails are the ones which are established under special acts. Now, if there is any special act which says that the convict has to be kept separately with that of the other people and other convict or under trials, then they can establish special jails and that person can be kept up there. Or if there is any apprehension that yes, that there is a threat to the life of that person, and under those circumstances, the court can establish a special jail and can keep the person there. Other jails, it is open, so based on the circumstances, situations, if the person has to be kept in some other place, or if there is any threat to his life, as mentioned in the special jails, so a new jail can be established. So these are the kinds of the jails or prisons that we see in India. Next, when will be a person imprisoned? So a person will be imprisoned like after conviction, during police custody, or during judicial custody, that is during the under trial procedure. So in these circumstances, the person will be sent for the imprisonment. Now let us see what is the difference between judicial custody and a police custody. So police custody, it means that the physical custody of that person, of the accused, will be with that of the police. Whereas in the case of judicial custody, the accused physical custody will be with that of the concerned magistrate. And in police custody, the accused will be put up in the police lockup, whereas in the judicial custody, the accused will be in the jail. And in police custody, the accused will have to be appearing before the magistrate within 24 hours of his arrest. And if the magistrate feels that yes, there is a requirement of continuation of his police custody, then they can extend it up to 15 days. Okay, and here again his medical checkup, everything will be done on a regular basis. Next, in the case of judicial custody, he will be kept in lockup until and unless a bail is granted from the court of law. Please note that there is so many misconception that even the police officers can grant the bail. No, the police officers, police station, they cannot grant the bail. The bail is granted only by the court of law. So this is the difference between that of the judicial custody and the police custody. Coming to the next, we will be directly jumping into the legislations which is governing the prison laws in India. The first and foremost is IPC 1860. Next we have Prisons Act of 1894, and also we have one more Prisoners Act, that is 1900. So 1894 is Prisons Act, 1900 is Prisoners Act. And next we have Identification of Prisoners Act 1920, and we have Constitution, and then we have Transfer of Prisoners Act 1950, Representation of Peoples Act 1951, Prisoners Attendance in Court 1955, Probation of Offenders Act 1958, CRPC 1973, Mental Health Act 1987, JJ 2000, Repartition of Prisoners Act 2003, Model Prison Manual 2003. So these are the total enactments which govern the rules, the laws related to prison in India. But basically there are 4 enactments that majorly fall into the place, that is the Prisons Act, Prisoners Act, Constitution, and the Prisoners Attendance in Court Act 1955. And also here we have to note that apart from these central rules and central legislations, the state government is free to frame its own jail manual. Okay, so if you are from the Karnataka state, then you will have a separate state rule, and if you are from Haryana, you will have a separate state, or if you are from Maharashtra, then you will have a separate state. So if you are a practicing advocate, or if you are interested in knowing more about this thing, so you will have to refer to the state rules for the better understanding. Next we have, we'll look into the first law, that is Constitution of India. So in the case TV Vateravaran versus State of Tamil Nadu, it was challenged that the prisoners, they were not falling under the Article 14, 19 and 21. They were not having this fundamental rights. So their prisoners' right was not in consideration. This was challenged in this particular case. So the Honorable High Court held that Article 14, that is right to equality, and Article 19, fundamental duties, and Article 21, that is right to life with dignity, they are available to the prisoners as well. Just because they are in the prison, that does not mean that they are not under this fundamental rights. So Article 19 is applicable even for them. Just because they are prisoners, you cannot tell that fundamental rights is not applicable to them. And also any provision which is mentioned in Article 21, that is no harm should be done for their right to live with dignity. On various cases, in the various judgments, the Honorable Courts of India have come up to these rights. They have recognized these rights under Article 21, 14 and 19 of Indian Constitution. That is right to inmates of protective homes, that is they will be provided with the protection in all the places. Right to free legal aid, yes, we have legal DLSA and other things, so they are supposed to provide them the free legal aid and educate them about the legal right that is available to them. Right to speedy trial, yes, their trial should be done at a speedy rate, because if somebody under trial is undergoing the imprisonment, then it is the duty of the Honorable Court to ensure that the trial takes place at the faster stage, and if that person is not accused, is not guilty, then he should be freed at the earliest. Right against cruel and unusual punishment, yes, no physical torture will be done to the jail inmates by any other authority. Any jail authority will not physically harass the jail inmates. Right to fair trial, yes, if any under trial person is in the jail, like is imprisonment, is undergoing imprisonment in the prison, then under those circumstances his right to fair trial should not be disturbed. He should be permitted to meet his advocate, he should be permitted to go through the documents, so, and also he should be produced to the court every now and then when the court has asked for. Right against custodial violence and death in police lockups or encounters. Yes, so they have right against this custodial violence and death in police lockups as well as the encounter. So police are accountable for the life of the prisoners. Right to live with human dignity. Yes, this human dignity that covers all the aspects, like they should not be humiliated, they should not be harassed, they should not be abused. So all the proper care and caution should be taken so that their dignity is not hampered. And right to meet friends and consult a lawyer. Yes, they should be allowed to meet their friends and also their legal advisor, that is their lawyer, when and how required. Again, the time limit, the time duration, the frequency, etc. It depends on the state rule. So if you want like more insights, like in your place how frequently it is available, then you will have to refer your state rules. Right against solitary confinement, handcuffing, bar fetters, and protection from torture. Yes, solitary confinement, it means that the person is alone, put up in the jail, like nobody is allowed to speak to him, nobody goes in front of him, etc., etc. So that is not permitted. And handcuffing, as we might have seen in movies and other places, that the person is being handcuffed and is being taken. Police officers do not have any right to handcuff unless and until the person whom they are arresting is trying to escape from them. If the person whom they are going to arrest is cooperative with them and is ready to accompany them, then under those circumstances they cannot handcuff. Only if he tries to escape, only then they can handcuff. And also, if that person, if that arrestee, that is, if that convict is turned out to be an like if the accused turns out to be a convict, even after that he can file a petition for violation of his Article 21, that he was handcuffed without any reasonable cause. And then right to reasonable wages in the prison. As we all know that the prisoners, they work in the prison, and when they work in the prison, they are entitled for the reasonable wages. We know that in prisons they do this hand materials, like dolls and clothings, and also we have hotels that are run by the jail inmates. So when they do all such kind of work, they are entitled to get the reasonable wages. This money will be handed over to them when they will be released from their imprisonment period. And next, prison as a system. So here in the prison there are three classes. The three classes are divided amongst the prisoners to provide them the facilities and to provide them the jail, like whatever, like VVIP cells, VIP cells. So we know all of that. So that is decided based on this classes. So we have class A, class B, and class C. So class A are the prisoners who are non-habitual offenders and are of good character, and who are in the superior mode of living, maybe by education, by social status, or based on their financial status. They were enjoying a superior mode of living, and they have not been convicted of any offences which are regarding to the cruelty, moral degradation, or personal greed, or any serious offence, or offences against property, offences, possession of explosives, firearms, or any dangerous offence, or they have not even abated or incited for such offences. So under those, if the prisoner is satisfying all these terms and conditions, all these criteria, then he will be termed as class A prisoner. Class B prisoner is the one who is accommodated to the superior mode of living because of his social status, education, habit, etc. And also this may include the habitual offenders also, but they are comparatively less that of the class A. And class B are the prisoners, the common prisoners who are not even class A and class B. So these reference to class A, class B, and class C prisoners you can find in the state rules. And in the state rules, when they provide the room facilities, they will mention about these classes. Now for example, if it is a class A prisoner, then he will be provided with a table, with a chair, with a bed, with a separate room or something like that. And also he can be provided with some more utensils or some additional features, an iron box, or the dresses that he can get from outside, like a VIP cell. You can consider it as same like a VIP cell. Next we have class B, wherein he will be given with little less facilities. Maybe there will be a double bed, like a bunker bed, wherein he'll have to share with two people. So all these facilities will be provided for the class B. And class C prisoners are like treated in a normal way, like they'll be based on the state rules again, and also the size of the jail, they will be provided the accommodation and other facilities. Next, we will be going into the Prisons Act of 1894. So this entire act has 12 chapters, which is divided into 62 sections, which are divided into the 12 chapters. So here this speaks about the appointment of officers in the jail. So the jail head will be the Inspector General of Police. He will be controlling and superseding all the prisons that are situated in the such state government. Okay, so we will be looking into all the things. He will be the head of the jail. And then after that we have a superintendent. Superintendent is the one who works below the Inspector General, and he will be looking into all the things. And then we have a medical officer, and this medical officer and superintendent can be a single person. And then we have one more medical subordinate, and after that we have a jailer and any other officers as a state government feels necessary. It will depend based on the size of the jail. They may have 2 jailers, 3 jailers. If it is a central jail, then there will be more number of the jailers and also more number of the medical officers, because the size of the jail is so big. And next, this all the documents related to the prison will be with that of the superintendent. So he will have major record, that is register of prisoners admitted and date of their release, one more book which states the date of their release, and also a punishment book. A punishment book is the one which provides a list of the punishment that is given to the prisoners. That is, if the prisoners they fail to follow or oblige any of the directions that is provided, or they fail to follow the guidelines that are established in the jail and they don't accord to the same, then under those circumstances they can be punished, they can be provided with the punishment, and that punishment has to be made in the punishment has to be registered in that of the punishment register. And then they will have one more register that is mentioning about the record of money and other articles taken by the prisoners. See, when a person is convicted and he goes to the jail, the first thing they will do is they will take all his valuable possessions. So that will be in the custody of the superintendent. So he will be, if he has any cash or if he has any valuable item, gold or something like that, then superintendent will take care of it. He'll keep it up in the locker, and when that person is released, the same will be handed over to him. And also, if the jail inmate he is earning his money in the form of wages and other things, again that will be in the custody of the superintendent. When he leaves from the jail, the same will be handed over to him. And next, coming to the jailer. So jailer and also for the certification process, I have put up the link and I have in the comment box, and I have pinned it. Please do fill that form and send me, because I can see many of you are commenting interested. So please do fill that and send that to me. And next we have the jailer. So jailer is a person who resides in the prison. So he will be like 24/7 available. Okay, so unless and until superintendent permits him to reside elsewhere, he should be residing in the jail itself. And he will be, as I said, he will be present during both daytime and night time. And yes, if the jail is more and if there are more jail inmates, or if there are any people who is believed to be escaping or any threat, then under those circumstances they can have additional security. But it is a jailer who is supposed to take care of all these things. And now, section 23 of this enactment empowers the prisoners to be appointed as the jail officers. Okay, they will be called as convict officers. So they will be doing these duties, and they are deemed to be public servants within the meaning of the Indian Penal Code. So these convict officers also will be paid salary as per that of the government norms, and when they are released after finishing their term of imprisonment, the same will be handed over to them. And this enactment also states that the male and female prisoners are to be stayed separate. They will not be mixed with each other, and they will be having separate buildings, so that they don't face each other, so that they don't come across each other. And also further, these male and female prisoners are differentiated based on their age. So plus 21 will be imprisoned separately, and the ones who are just hit the puberty will be separate. That is 18 to 21 will be in a separate place, and 21 plus will be in a separate place. And then again they are further divided into convicted and unconvicted. So convicted criminals shall be kept apart from that of the unconvicted criminal prisoners. And again these are further divided as like civil prisoners and criminal prisoners. So civil prisoners also will be kept separate, and criminal prisoners also will be kept separate. And then again, if the state rules says any other bifurcation, then that can be done accordingly. And then what happens when a person is taken to the jail? So the first thing they are going to do is like they are going to search him, and that is a physical search will be conducted, and all his possessions will be taken. Any weapons, prohibited articles, or any of his valuable things will be taken into the custody. And then after his admission, as soon as his admission, he will be examined by the medical officers. If it's a high profile case, then a team of medical officers, like the authorized medical officer, will be doing it, or else the jail authority will be doing it, the jail medical officer. So he will be entering all the documents in the book, like if he is all the minute details, like if he is suffering from BP, sugar, his BP level, his sugar level, and then also his body marks, if there are any scratches and if there are any wounds, or if he has if he is going through any of the tablets, like any medication, whatever it is, all details will be collected by the medical officer, and this will be entered into the book and as a register, which will be in the custody of the superintendent of the jail. And yes, and later on that they will be he will be also assessing that whether he is fit for rigorous imprisonment, or whether he is a delicate person, what he is, how he is. So all details will be taken by the medical officer. And in case if it is a female prisoner, and this search and examination will be carried out by the female doctor. Okay, and also all the jailers, whoever are there, they are not, if they are not females, they are not allowed to enter into that premises where her search is being done. So it is all by the woman, and they are supposed to do it with the utmost dignity. And also if they are if they have any valuables, as I said, it may be gold, cash, or any costly watch or something like that, all these things will be placed in the custody of the jailer, that is, which will be with the superintendent of the jail. And next we have this following up of the profession, or doing that of the work. So civil prisoners, they can do any kind of trade or profession or work with the permission of the superintendent, whereas criminal prisoners, they are who are into the labor, like during the punishment, they are said that when they are convicted, they were said that they will be doing the labor work in the jail, etc., etc. So they are supposed to do accordingly to the directions of that of the superintendent of police, superintendent of jail, and they are supposed to work for 9 hours in a day. So more than 9 hours in a day, unless and until there is an emergency, they are not supposed to work. And the jail inmates who are into the labor work, the medical officer shall examine them from time to time. And also he will be looking into the wounds, his compatibility, whether he is fit or not, whether he can do it or not. And also he'll also look into his weight loss or weight gain journey. So whatever it is, how it is, all the things will be noted. And if the medical officer feels that particular jail inmate is not fit for doing those kind of labor work, then he can recommend the same to the jailer in return to the superintendent. So that person will be exempted from doing the labor work till he becomes medically fit. and also punishment will be provided for violating the prison rules. Now if a prisoner, he was supposed to do some physical work, some labor work, and he has not done it, then or he disobeyed the instructions that was given, or he caused damage to the jail property, then under those circumstances he can be punished. So this punishment may be in the form of warning or hard and severe labor, withdrawal of facilities, or any other manner as the jail superintendent feels fit. And in case of death of the prisoner, so the police officer should take maximum care that there is no custodial death that is happening. But in that event, if there is any custodial death, then this was to be the first thing they have to do is they have to approach the medical officer. So, and then the medical officer should make a note of all these things. That is, when what was the illness that he died of. So when was the first day he said that he is suffering from this illness, and was he engaged in any kind of labor that day, what was his food that particular day, and was he admitted to the hospital or not, and when did the medical officer came to know about it, what is the nature of disease, and when was the last seen, like when they saw him alive, and when the prisoner died, and if the post-mortem is to be made, then on account of the appearances of that, so that special remarks also has to be mentioned. So in the event of death, so all these reports should be submitted to the court regarding his death. And so this is all about the Prisons Act. And now we have Prisoners Act of 1900. So this is part, it has 53 sections in part 8 parts. But many of the sections are repealed, so we have very less, hardly around, I think not even 10 sections are retained in this, and rest of all of them are repealed. So this Prisoners Act, in one sentence, it says that if a person, that is if a prisoner, he is of unsound mind, or if he is a lunatic, under those circumstances, he should be removed from the prison, and he should be put up into the mental care hospital, and he should be provided with proper care, and that is the duty of the government. So, and also it says about the transfer and delivery of the prisoners from one jail to another jail and other things. But this is the major section of this particular enactment, that is Prisoners Act of 1900. Next we have Transfer of Prisoners Act of 1950. So this is a very small enactment. We have only 4 sections in it. So this enactment is only about the right to transfer prisoners from one state to the another state. That is one jail to the another jail. So this can be done to in the rehabilitation and vocational training program. And also if there is, if the jail is overpopulated, and also what I can say, if there are more jail inmates and it is causing congestion, or if there is any high profile case, based on the nature, the person can be transferred from one jail to the another jail, that is from one state to the another state. So this is empowered under Transfer of Prisoners Act of 1950. So as you have seen, all these enactments, they are like very old enactments, and recently we had some amendments, and we have some model rules that are to be brought in, but nothing as in the plate. Next we have Prisoners Attendance in Court Act of 1955. This is another small act, that is, it has only section 10. So this states that when a prisoner, that is an under trial prisoner, he is in the jail, then under those circumstances, when the magistrate, concerned court officer, he issues the order to that jail, to that prison, then the officer shall cause him to take him to the court and produce him before the court. So as in such the date and time on which it is mentioned by the order sheet that is given by the court, and also shall detain his custody in the jail, in the court also, and they will be accompanying him and until and unless the jail, the judge or the presiding officer asks them to move back to the jail, they will be they will be in the court premises or any other place premises, and they will be taking custody, that is, they will be detaining the concerned prisoner. So this is empowered under the Prisoners Attendance in Court Act of 1955. And the facilities provided in the jail. So these are the four central legislatures that we have seen. Now we will be coming into the facilities that are provided in the jail. So this facilities provided in the jail is again coming under the state manual, and the state has always ensured that they provide best facilities to their jail inmates. This when you read to the jail manual or the jail rules, the prison rules of a particular state, you can find the diet sheet, and also you can find the clothing facilities. Usually they give clothes every summer and every winter based on the climate of that particular area, and also food will be given on that basis. Like if it is a North Indian state, then they will be preferring more of rotis, chapatis, etc. Wherein if it is a South Indian state, they will be providing more of rice, ragi thing, and ragi balls and other things. So generally in common, the facilities that will be provided like TV, newspaper, again the newspapers, they will be selected newspapers, and this newspapers, before handing over to that of the jail inmates, it will be verified by the superintendent of the jail. So once he looks into it, and if he feels that yes, this paper can be given and this shall not trigger any violence in the jail, then they can provide the same. And then they will provide indoor games like chess, carom, shuttle, tennis court, etc. And also the telephone facilities are also provided in the central prisons, district prisons and special jails. They also provide yoga, meditation, legal aid, art of living classes, moral lectures by various NGOs. And also in larger prisons, you can find the facilities of the libraries also, wherein the jail inmates can access the same. And also they will be having various sports and games competition, literacy competition, cultural activities, etc. And also they will be also celebrating this Republic Day, Independence Day and Mahatma Gandhi Jayanti. And also based on the state rules and the state culture, they will be celebrating the state festivals also. So these are the certain facilities that are provided in the jail. And to add on it, we have musical programs, musical instruments like electronic tambura, sitar, etc. that are provided to the jail inmates. And also education facilities provided to the illiterate prisoners as well as the literate prisoners. There they provide this distance education. So they will collaborate with the universities. They are offering the distance education process, and from there the jail inmates are free to enroll themselves to the course that they are willing for, and they can complete the same. And also that from in the jail, if they want to do any certificate course or something like that, then even then the jail authorities will facilitate for the same. So the person who is in the jail is given all chances, all opportunities to evolve as a better human being. Next, children of prisoners. So this issue majorly came up before our Honorable Supreme Court on in the year 2006. Okay, so this was in R.D. Upadhyay versus State of Andhra Pradesh and others. Wherein here the question was right of development of a child whose parents are in jail. Okay, and especially the mother is in the jail. So the Supreme Court asked various state governments to file affidavits and union territories as well also. So to know what is the procedure that they follow. So looking into all those concepts, our Honorable Supreme Court, it came up with the following guidelines. So the first one is the child cannot be treated as an under trial person or a convict while the child is in jail with her mother. So by this line you can understand that yes, a child can be residing in the jail with his or her mother. So this is up to the age of 6 years. So the child below the age of 6 years, if the mother is in the jail, then the child can accompany. So when such child accompanies, then the child is entitled for food, shelter, medical care, clothing, education, recreational facilities and all other things as a matter of right. So the child will not be deprived of any right just because his or her mother is a jail inmate. Next, we have pregnancy. So when a woman convict or when a woman prisoner, she is brought to the jail, and during her medical checkup, if it is found out that she is pregnant or any time thereafter, even after she was residing here for 1 month, 2 months, then after also it is disclosed that yes, she is pregnant, then under those circumstances, it is a responsibility of the jail authority to make proper arrangement for her medical facilities. Now, if that particular hospital does not have, particular jail does not have adequate medical facilities, then that prisoner should be transferred to that of the another prison which has the adequate facilities, and she will be provided treatment at the district government hospital. So the district government hospital head will be providing all details of her health, duration of pregnancy, possible date of delivery, so on, all the report, and this all the report will be sent to the Inspector General of the prisons. And so that person will be provided the reports on the time to time basis. And also it is the duty of the jail authorities to provide prenatal and postnatal care for the both mother and the child. So they have to ensure that they are providing adequate facilities like proper bed facilities, proper food, and also if she requires any medical attention, then they should be available for them, for her. So all these things has to be taken care by the jail authority. And when the child is born, like usually what they give is like they release her on a parole or on a probation if she is a casual offender or if the offense is minor, okay, to ensure that she has a good delivery and the baby is coming out healthy. But if there is any high security risk or if there is any chance if she has committed a grave offense, under those circumstances, she will not be granted a parole or a probation. So what they have to do is like the jail authorities again are here bound to take her to the hospital in time and ensure that her delivery is done with all due care and caution. Now, when the child is born in the prison, in the birth certificate, the place of the birth will not be mentioned as that of the prison. What they will do is like they will be mentioning the address of the locality. Now suppose if it is in the what I can say in a particular place, then they will mention that particular area name. They will not mention that the child was born in the prison. So this was because the child should not be affected in his future or in her future because the name prison is written in her birth certificate. And then all the facilities related to the naming rights of the child should be followed in the jail authorities. And yes, female prisoner, as I said, she can keep her child with her till the child attains the age of 6. So once after completing this age of 6 years, child will be handed over to the custodian, that is to their family member, or if the family member they are not able, like they are not willing to accept the child, or if there is nobody, then the child will be sent to the suitable institution that is run by the social welfare department. So the social welfare department institution will take care of the child. And then such child will be kept in that institution till the prisoner, that is his mother, is out from the jail. And yes, so once the child is in the custody of the social welfare department, then the child and her mother can meet at least once in a week. So it is the duty of the director, social welfare department, to ensure that the child should be brought into the prison and should be meeting his or her mother. Now, what if the female prisoner dies? If the female prisoner dies leaving behind the child, the superintendent shall inform the same to the district magistrate, and they have to arrange for the custodian of the child. So if there are no relatives who are unwilling to who are willing to accept the child, then the district magistrate again will hand over the custody of the child to the social welfare department, and they will call upon for the adoption. So if the social welfare department feels that yes, this person can adopt the child, then they can provide the same. And then when in jail, both to the mother and the daughter, the jail authorities should be providing all the clothing facilities. So again here you can see that local climatic requirement. So it is a discretion of the state and union government to ensure that they provide the clothing facilities as required for that particular climate region. Now suppose if it is summer, then they should be providing those kind of clothes which is easy to breathe, which does not cause so much hot in the body, and if it is cold area, then they should be providing some warm clothes. And also again it has given the discretion to the state and union territories to provide good food, like as per the medical norms. Again it depends on the state, like what the food they are eating, what is the preference food, all the things they have to keep in mind, and they have to give according to the medical norms. And if they need a separate food, then they have to make it for the child, especially for the child, for the to fulfill all the nutritional need of the child. And to baby feed, they should be giving proper utensils, and also they if they want, then they can give some warm or some electric stove or something by which she can warm the milk, or she can provide the same or any food or something like that. Then clean drinking water should be provided to the children, and this water must be periodically checked. And these children should be regularly examined by the lady medical officer. Okay, so it is a lady medical officer who is going to examine the children and the physical growth of the children, and also provide the timely vaccination. So if there is, if the doctor suggests that the child is malnutrition or something like that, then they should be providing more food, more diet, like they have to increase the diet of the child and give more nutritional intake. And if they suggest that the baby needs extra clothing or something like that, then they have to provide the clothing facility also. And if the female prisoner, the mother, she falls sick and she cannot take care of the baby, or she is not able to give a bath to the baby or an oil massage to the baby, then under those circumstances the jail staff will be assisting her in the said process. And a separate sleeping facility should be provided to the mother and child, so that it is adequate, clean and hygiene. And also the children of the prisoners will have the right to visitation. As I said, the social welfare department is supposed to do it. And suppose even if they are with a guardian, under those circumstances the child should be allowed to meet his or her mother. And the prison superintendent has right to ensure that if the child is if a child is above 6 years of age, but still if it has to stay with his mother, then the police superintendent can authorize the same, can provide the permission for the same. Okay, so this is the right that is given to the police superintendent. And then next we have education of the children of the prisoners. So the child, whoever is residing with that of the mother, even if it is below the 6 years of age, should be given with the proper education and recreational opportunities. Okay, so while the mother, if she is working in the jail, then the child should be in the in the custody of the female wardener, and that wardener will take care of the child, like the food need, or will train the child, will teach English, will teach basics to the child. And they can be a nursery that is attached to the prison, wherein the children of the women prisoners will be looked after. So children who are below the age of 3 years shall be allowed in the crèche, and also those between 3 and 6 years will be looked after in the nursery. So the prison authorities shall run this nursery outside the prison premises. So it will be in the next, usually in the next road of the jail, wherein the children will be taken over there, and they will be provided with the basic education up to the age of 6 years. And in many states wherein there are small and sub jails which are not adequate to keep the growth of the child, so what they have to do is like they have to transfer such mother and the child from that particular jail to the central jail or the district jail preferably. This has to be done with the good interest of the child, like it has proper biological, psychological and social growth. And also the child and the mother should not be kept in the crowded barracks, that is in the crowded place wherein they meet across women convicts, some other women convicts under trials, and who are indulged themselves in the violent crimes and who are having a different mentality or a criminal mentality, so that it does not impact the personality of the child, so that the child's mental status remain as innocent as it is. So therefore, the child has to be kept separate, and it has to be on a priority basis. Next, this speaks about a diet. It has to be given to the prisoners. So here you can see it is a big report. This diet was suggested to the Honorable Supreme Court of India by a report that is prepared by Dr. A.M. Dwarakdas Motiwala and Mr. Sanjay Parekh. So this is a detailed diet which says that how they have to give the food. And now here we can see that this stated that this report stated the importance of the breastfeeding. Okay, so the document submit recommends exclusive breastfeeding on the demand of the baby day and night. So this report basically tells about the same thing, and then it is stating about the food that is given, that should be given to the baby, along with the milk that is to be given to the baby. So they have made very clear that it shall not be diluted milk. So it will be undiluted fresh milk. So based on the age and like age group of 6 to 12 months, 1 to 3 years, 4 to 6 years, they have suggested cereals, millets, pulses, milk, roots and tubers, green leafy vegetables, other vegetables, fruits, sugar, fats or oil, and also one portion of pulse can be exchanged with that of the egg, meat, chicken, fish. So it has provided all kind of food that has to be given to the child as well, during the stay in the jail. So the Honorable Supreme Court has advised to the state governments based on this report that is submitted, and it has asked them to provide the food of these nature to the jail, to the children whose mother is in the jail. And next we have, as I said, the jail manuals and other relevant rules and regulations, instructions that are to be governed by the state government. And also it stated that it should not be just in the letter, it should be implemented in the spirit as well as the same spirit also. And also it said that the state legislatures may consider passing necessary legislations whenever necessary, having regard to what is noticed in this judgment. And also it said to this state legal service authorities, that is LSLA and DSLA, that they have to inspect and they have to monitor and they have to ensure that these directions related to the child and mother are implemented both in the letter and the spirit. And then we have one more guideline stating that if the child and mother both are in the jail or prison, then those cases should be disposed of on prior this thing. And also it shared this judgment to all Union of India, state government, union territories and High Court for necessary action. And also it asked all of them to submit a report within 4 months, that what are the directions that they have taken. Now coming to next, we will be speaking of the duties of the prisoners. So as I said, if the prisoner is not complying with that of the jail function or prison function, then he can be punished. So what are his duties? The first duty is to obey all the orders and instructions that are issued by the competent prison authorities. And also the jail rules and regulations they have to follow based on the state rules. Like after 10 p.m. they cannot keep the lights on, and they have to be out of the bed by 7 a.m. and they have to wash their own utensils, and they have to come for lunch by this time. So they have so many rules and regulations, and that has to be followed and adhered. And they have to follow cleanliness and hygiene. They cannot be dirtily roaming here and there. They have to be clean and hygiene. And also they have to respect the dignity of the every inmate, prison staff, and also the functioning of the jail. Like they should not be teasing one jail inmate, telling that you have done that, you have done this, etc. So that thing should not be done. And also they should not be hurting the religious beliefs or faith of the other person. And yes, they should not be damaging any jail property. Okay, so they have to take proper care and caution for that. And also they have to help the jail prisoners, like the prison officers, to perform their duty in a better manner, and also to have a better conducive atmosphere in the prison, so that they don't nag always, they don't pick up fight, they don't disturb the peace. So they have to follow all these things. And next we will be speaking of conjugal visit rights. So this conjugal visit rights is the one which is a hot burning topic as of now, related to that of the Indian prison laws. So this conjugal visit rights is defined as a scheduled period in which an inmate of a prison or jail is permitted to spend several hours or days in private with that of the visitor, usually their legal spouse. So they have the right to spend in person. So it is like what I can say, in person, not in the public. Like see, as of now we have the provision to meet the family person, advocate, etc., etc., wherein it is in an open place. But this conjugal visit rights is about meeting a person, their legal spouse, in person. So this concept is already recognized in countries like Canada, Germany, Russia, Spain, Belgium, Saudi Arabia, Denmark, to some extent in the US as well. And we have Brazil and Israel that is even allowing same-sex conjugal visits. Okay, so Brazil and Israel have moved one step ahead, and they have permitted for this same-sex conjugal visit as well as. The same. In India, we have this conjugal visit right reference in two times, that is specifically 2 times. That is one in the year 2015 and the other one in the year 2018. So 2015, it is Punjab and Haryana High Court, wherein it said that it was in a case wherein it allowed conjugal visit and also artificial insemination for inmates. That is by IVF method, they can consume and they can donate their sperm to that of their family, to that of his wife, and they can have the babies out of the wedlock. Though he is in the jail, he was permitted to do it. And again in the year 2018, the same issue, it popped up in the Madras High Court, wherein there is a convict who is serving a lifetime imprisonment. Okay, so his wife had filed for this writ petition asking for this conjugal visit right, telling that he is in the jail and he is serving the life imprisonment and etc., etc., and she wanted to have a baby out of that wedlock. So under those circumstances, that person who was in the central prison of Tamil Nadu in Tirunelveli district, he was granted a 2-week conjugal visit right. So he was given like a right to visit like for 2 weeks. This right was given for the 2 weeks, and it was said that it is for purpose of procreation. And Madras High Court, along with this passing this iconic judgment, it also said that if we have to like India, it is high time that we look into these concepts and we bring out a new law which provides for this conjugal visit rights. So I would like to see that this conjugal visit right is one of the burning and hot topic, and also if anybody is looking for any dissertation or any kind of research work, then this conjugal visit rights is a very interesting topic and very booming topic as well. Yeah. So now I would like to wind up this session quoting Oscar Wilde. So he said that every saint has a past and every sinner has a future. So this is basically it means that whoever saint we see, so he had a past, he had some incident why he left all the worldly pleasure and why he opted for the same thing. And yes, every sinner, every wrongdoer, he has a future, and henceforth he should be given a chance to correct himself, to bring out the best in him. So that is where our prison laws should look into. And as I said, we have many gray areas that are to be covered in our prison system, like maybe related to more of the children laws. We need more of those. Though we have the Supreme Court guidelines and certain state rules, I think it is high time we have a central enactment which provides on an overall jail manual and other things. And we have many laws that are in the pipeline, like we have model prison reforms, we have modern prison rules, and so all of them are in the model, and we have had many committees also, but not majorly their recommendations were implemented. So this is a high time that we look into it, and yes, we identify the sinner and provide them one more chance to revive themselves. I hope this session was useful, and I could give a overall brief of this prison laws. And whoever are interested for the certificate, please fill up the form and share the same to me. And yes, and if you have any questions, please do drop in the comment section, so that I'll look into it and I'll be answering as much as possible. And if I'm not able to answer any, then please get back to the comment section, because I may not be able to see it here. Yeah, so there are so many comments. Okay, good evening everybody. Yeah, good evening. From where can we download or find the material regarding this? In the comment section I have pinned in the form. Please do fill that form and submit it. And I'll be getting your details, and I'll be sharing the same via mail and WhatsApp. Next, good evening. Yeah, please, all of them who have commented interest, please do put it up over there. And I have one more question. Does it really happens practically that convicted and I think it is convicted and unconvicted prisoners are kept separate? Yes, it happens really. They are kept separate. But what happens is, like, basically the main difference that is made is the men and women. So they'll have separate prison, and in prison everybody come together. They speak together. So that thing happens. Yeah, I got it. Unconvicted. Very insightful session. Thank you so much. Very informative. Thank you. Yeah, please share PDF notes. Yes. Yeah, I'll surely share with you. Because yeah, Mansi, surely I'll be doing it. Would be great if the link for downloading the material could be shared. Yeah, as I said, please do drop your details, contact details in the form, so that I can share the same. Please provide link for material. Yeah, sure. I'll provide the link for this material. Please share the PDF. Yeah, I have Sampada ma'am. I joined a bit late. Did you cover parole also? Yeah, if you have not seen the video, this video will be available in the said link. So please do look into it, so that you can find the same. You can get access to all the things. Yeah, I hope there are no more questions. If there are any, please do let me know. I'll wait for one other minute. So if you have any more questions. Yeah, thank you everyone. I think we are good to wind up. Yeah, thank you everybody for joining here. And yes, the link for the study material and other things are in the comment section. So I'll be putting up in the comment section as well as the same thing. Yeah, I'll be sharing the study material maybe by tomorrow first half. It will be done. And yes, thank you everybody for joining, and it was nice meeting and speaking to all of you.